Welcome to Conflict to Connection, the podcast that helps families navigate separation with compassion and understanding. I'm Mitch, a child consultant at Civilized Separations, and I'm joined by my co-hosts, Bill and Bella. Together, we tackle tough conversations about divorce, co-parenting, and creating healthier family dynamics. Whether you're navigating a separation or just looking for better ways to connect, this podcast is here to guide you every step of the way. So, welcome to Conflict Connection, the podcast where we talk about all things divorce, relationships, and parenting. I'm your host, Mitch Wilkins, a child consultant at Civilized Separations, and today I'm joined by Bill Hewlett, the founder of Civilized Separations and a regular guest on this podcast, and a special guest, Professor Anne Barlow, a professor of family law and policy at the University of Exeter, and has spent over 2 decades at the forefront of research into adult relationships, family justice, and child-inclusive mediation and out-of-court dispute resolution. She led multiple national studies like Creating Paths to Family Justice and headed the HEART Project, which explores how mediation can better support children's mental health during separation. So welcome and thank you for joining us.
Thank you.
Okay, so Anne, it's a pleasure to have you on. You've had a really fascinating career from early days as a solicitor to becoming one of the leading voices in family justice reform and family dispute resolution. Can you tell us a little bit more about what originally hooked you into this line of work?
Having come from practice, I was really struck by how little help there was for people who were going through family separation. And so when I became a researcher, I was interested in looking at it from an academic point of view. But I was always very keen to help those that found it most difficult to access support and advice. And over the years, I think that's got more difficult for those without resources. So I was very keen to make sure that the research I did was focused on trying to make things better in terms of the legal process and the way people understood it, and also to make sure that children, who are after all typically the most vulnerable family members, also benefited rather than were harmed by the system that was clearly aiming to help them but didn't always succeed. So I suppose that's how I came to be interested
and did you
in this
find
work.
that, like, was there a moment that made you want to kind of move into doing that work? Was there kind of a moment as a solicitor that you went, this needs to change, something here needs to change? Or was it over a period of time?
When I moved from practice into academia, it was the fact that people believed in the common law marriage myth.
Okay.
And they thought they had legal rights, which they absolutely didn't have. So my very first piece of research was looking at that and how people could be so wrong and believe so strongly that that was the case. And as part of that, I suppose I got to see more closely how, when there was separation, whether through divorce or through separating for cohabitation, the process actually harmed those involved. And therefore, I was always looking for ways to both make sure people understood their own position and rights, but also to sort of smooth the process and make sure that they found the right pathway, if you like, to resolve their sorts of problems.
So you spent a lot of your career kind of exposing those gaps in the family justice system and how best that you could resolve them. And Bill, I feel like you've kind of done the same at Civilized Separations, and that's what we're trying to do in this podcast, specifically kind of expose those things and then maybe voice how we resolve them as well. And for you both, is there kind of a moment or a case again that kind of made you feel like, one, this is not how the family justice system should work, and two, maybe opened your eyes to how it could possibly change, or maybe a piece of research that you did as well?
I can remember. Well, I mean, for me, it's such a common thing to kind of meet people who've been in the family justice system and got to a particular point, often become more antagonistic or more unhappy or more angry with each other as a result of the process they've been through. And to then have them adopt a different way of looking at the world and a different way of thinking about what's happened and a different take on each other, and to have everything that kind of falls in place as a result of that. Sometimes I'd be briefed by the lawyers about these terrible people who were incredibly stuck. But because the process that I was offering was a very different one in terms of a sense of being child-focused and being very invested in making sure the child is thriving, people were stepping up, becoming different people. So I kind of feel like every time I see the contrast between what the system has done to them, because you were talking before about effectively they were both kind of going to a system that was supposed to help them, but actually didn't. I straight away find myself thinking, why? Why do we have that? Why are we in that situation where people are getting something they don't need or want? What's going on? Because the people who are offering it want to help. The people who need it are asking for it. Why on earth aren't they getting it? So, yeah, I feel there's a very strong sort of weird dichotomy where people are effectively seeking out help and getting something that makes them feel worse.
So constantly seeing that fact that something needs to change because you feel like you're working against the system that's in place.
Yeah.
I discovered a socio-legal research, which I hadn't really appreciated because it was quite new when I first started out, to actually, for lawyers or academic lawyers, to look at the legal process from a societal point of view. So sociologists would often look at the law as sociologists, but lawyers had never sort of looked at it the other way around. And I thought, oh, that would be really interesting to sort of know what the law was and what its aims were, but actually look at how it affected people on the ground and try and persuade, perhaps with more effect, that the policymakers within the process, you might have more effect than if you were a sociologist and just deconstructing it in a way that was very sort of academic and theoretical, but wasn't really aimed at changing the system. It was just critiquing the system. So I suppose I always wanted any research I did to try and be impactful in terms of the policies when law was being reformed. So it was really good to do some research where you worked with the Law Commission and also with the Ministry of Justice or the Department for Work and Pensions or the Department for Education, so that you were trying to bring all the actors, if you like, together into the same room in order to change the process. And that was particularly so after the withdrawal of legal aid through what we call the LASPO Act. The Legal Aid Sentencing and Punishment of Offenders Act 2012, but we call it, known to its friends as LASPO, or its enemies almost as LASPO, because it was a very cruel act which was aiming to push everybody into mediation. Now, as much as I respect mediation and think it's a really great thing for people to do, it's perhaps not right for everybody, and to just withdraw legal aid so that people weren't getting advice and being pushed into a situation where they had to agree if they wanted any sort of support through the process or go to court and represent themselves, seemed a really, clumsy, to put it mildly, way of approaching the problem.
Because so they were removing legal aid in order to push people towards mediation in a good sense, but you feel as though that has kind of worsened the problem.
Well, we were doing some research on non-court dispute resolution, and the aim was really to look at which processes suited which cases and which parties.
Okay.
And when we started the project, there was talk about expanding legal aid not only to mediation, but also to collaborative law. And there was legal aid in place for solicitor negotiation and for being represented at court. And halfway through the project, the Act came into force, all of that went. The only legal aid that was available was for mediation and only for the party that was financially eligible at that. There were very, very stringent exemptions for those who could prove they had experienced domestic violence. So everybody was just left wondering, well, what do I do? Because the one thing people knew about separating, and I'm not saying that's a good thing, is that that it was a legal process. So
Yeah.
particularly if you were married, and therefore you would go to a solicitor, and all of a sudden the solicitor was saying, well, we can give you half an hour free advice, but that's it, because there's no longer any legal aid. So if you could afford it, you could either go with the lawyers, but it changed from being a sort of carrot process where people were being persuaded in a positive sense to try mediation into very much a stick process where it says you have to do this. And given that mediation was supposed to be a voluntary process, it didn't seem a very good approach. And it did have a lot of unintended consequences in that it increased rather than decreased the number of applications going to court. And it decreased the number of mediation starts, which was the exact opposite of what they were hoping for.
Oh, gosh.
Now, since then, things have changed. And I think things have got a bit better. But that's what happened. And we were in the middle of this project when the law changed, which is never good, although it was very interesting. And we did capture a moment in time where people were trying to find online help, trying to find out how to navigate the system on their own, not really knowing where they stood. They were Googling things and ending up with like Australian law, which was totally different, or American law. It was just mad. They really were left to their own devices because there was no proper central information. There was no guided route through the system. The courts were instructed to send them back to be assessed for suitability for mediation. Mediators could only give information, they couldn't advise. And for a while, everything was in chaos. And so, I mean, we were interviewing people who had divorced over a 15-year period. So we sort of captured people before
and after,
during, and then after, when things were beginning to settle down over that period. So it was that made me think, well, we've got to bring all the actors in this area together to do something positive for the people who were being affected so adversely, and to make sure that those who are suitable to mediate do take that path, but that the other pathways where those are more appropriate are opened up. So that was initially how we got started looking at this area.
And when you were looking at it, you're talking about that people were moving to online resources. So because there was no legal aid anymore, and because maybe if you couldn't afford a solicitor or they weren't giving you enough information, which they couldn't, people have been moving onto online. And Bill, you have done articles about mediation online. And I know that research had a lot about how the increasing number of people that were moving online, and children also going online to find information about what they can do. And due to those kind of huge surges online, what are your concerns about this movement to online legal and mediation advice?
Well, it's a bit of a wild west, and I think it really needs to be tamed in a way that people can navigate it better. There's lots of different issues, but the first of all is getting to the accurate information for their situation. So knowing whether, if there is domestic abuse, for example, then maybe legal advice is a really good thing to get early on. If they don't need that sort of assistance, knowing how you find a mediator who is qualified, if you like, accredited to be a mediator, the types of mediation that are perhaps available in different contexts for people. And also just feeling confident about the fact that you are choosing an appropriate path for your type of situation. So at the moment, I don't think still there is proper triage for people who are facing a very emotional and traumatic situation where you're not at your most rational, you're not at your best. You're trying to do the best often for your children if you have children. You often feel betrayed or hurt or guilty. You're not emotionally ready to actually make these big decisions. And actually, in most life-changing situations, what you get is advice. And that's actually quite difficult to come by.
Yeah.
And I don't know how much people trust the internet.
Yeah.
The sorts of groups they do trust are not necessarily helpful to resolving this dispute in the best way possible. So we found that people would go to like an echo chamber, if you like. So if they felt, well, it was all the mum's fault, so they might go to a sort of father's group that was perhaps a bit militant about blaming mothers all the time, or mums might go to a mum's group that was quite polarized and just looking at things and saying, oh, you mustn't let him see the child. And
So it like enforces their already preconceived ideas.
Exactly. Whereas you sort of need a better neutral
voice,
but also people also felt, and I understand it, because in our research, what a lot of people said is you needed to feel somebody was on your side because your life was falling apart. And I don't think that was meant in the sense of, take up arms and be conflictual to the other party, but just to trust who you were getting information advice from, be that the internet, be that, and often they felt a bit at sea if a mediator, for example, said, well, I can't advise you. So then they'd go to something, I don't know, I'm not saying Mumsnet give bad advice, but you would go to something like Mumsnet because you trusted Mumsnet, but perhaps Mumsnet wasn't necessarily the best place to get your legal advice from, particularly if it was coming from other mums. You perhaps got divorced or separated at an earlier period where everything was different, or things of that nature, and vice versa for fathers. And you end up exacerbating the hostility rather than bringing it down. And then at the moment, everybody goes to be assessed for mediation and starts mediation. It's probably already perhaps too late, where people have become entrenched in quite polarized positions. I think things are improving, but I still think people struggle with finding trusted sources, finding their way to and then through different pathways that can help them in their situation, and feeling confident that they are doing the right thing for themselves and for their children, typically. So I think they get off to a bad start the way things are at the moment.
I suppose people don't even know what the right questions to ask online are, let alone wanting some sort of advice. Where do you find that if you don't know what questions to ask?
And there is a lot of information, but until it affects you, you don't sort of take it in. You might have heard of mediation. I mean, we found that people went to the internet, they went to family and friends, mainly as their sources of advice. And then lawyers, that sort of was the order that people were looking for advice in. But a lot of people hadn't heard of mediation, or if they had, they weren't very clear what it was or what it meant. And they were a bit suspicious of it, just not knowing where to go, who to trust, how to get the help they needed, not wanting to exacerbate things, but also not wanting to be shafted, to put it, colloquially, by their partner either. They wanted to feel that what they were doing was appropriate all round for the post-separation family.
When you were speaking just then, you were talking about mediators, kind of people going to a mediator and or being assessed and then not being ready or not being too entrenched, or being told by the mediator that they can't resolve their issues, they can't help them. And I know that in the Creating Pathways to Family Justice, you wrote about how parties need to be emotionally ready to engage with dispute resolution. And I was just kind of thinking about that, and I had thought, does that readiness as a kind of precondition to mediation, does that risk excluding some people who might need the mediation most?
Well, I think the way it is at the moment, you're assessed for suitability for mediation, but that doesn't include, typically, a test on whether you are emotionally ready. And I think that's one of the things I would like to see change. And often one party is ahead of the other in accepting the separation and the need to make arrangements. Particularly if one person has been psychologically leaving the relationship over a period of time and it comes as a complete another shock to the other person, they're not always ready to engage with the post-separation arrangements. Perhaps they're hoping they'll get back together. Perhaps they just can't believe it. Perhaps they're just not in a position to make big decisions. So I think if you try and make big decisions too fast in those sorts of cases, you risk the mediation failing. Whereas if you can make some small steps, see how it goes and come back when both parties are more at the same, when there isn't a sort of imbalance between their readiness, then I think that goes better.
Okay.
So I'm not saying don't do it, but I think you need to take it in stages so that the other party can catch up.
I read about your articles about emotional readiness. I found myself wondering about whether mediation is ready for the people rather than the people being ready for mediation. I found myself thinking that readiness is for me, a kind of fluid concept. I certainly often see people initially who are not looking like they're ready. I often feel that the process they've been through has kind of made them less ready than they were perhaps before they began the process, where they might have become more upset or more angry as a result of the process, and therefore become less ready. And the idea that people have to kind of fit into mediation, I suppose, it echoes a concern that I have, because I feel that in many ways you're talking a lot about rigidity and inflexibility and the way that things are implemented with a lack of nuance or delicacy or flexibility. We're asking people in many ways to kind of fit into a process that will help them as long as they are suitable, or as long as they're ready, or as long as they're good enough. So I kind of feel that what you're describing is you're noticing that there's a clunkiness to it, to the way well-meant principles are implemented. I'm just wondering, I'm just curious about your thoughts in relation to what's going on with the thinking, what's happening where, like for instance, that piece of legislation where people are no longer able to access legal aid with some bizarre thinking that would make them more open-minded in a way. What's happening with the people who implement these things? What's happening with the legislation? What's happening with the bureaucracy where good ideas are somehow not actually getting to the point of being accessible?
Well, I think, to be honest, the reason they implemented that legislation was because mediation is cheaper than paying for legal aid for two lawyers. Even if to pay a mediator through the legal aid at very low rates typically is still cheaper than from each party going to a lawyer. So I think the cost, the hidden agenda of costs,
About money.
yes, was about how they implemented it. So it was implemented for the wrong reasons. The rhetoric was around mediation being cheaper, quicker, and less conflictual. But the less conflictual was almost undermined by the way
It's
it was
convenient
implemented.
in a way that you're looking to save money.
Exactly.
And this was a way to look good and save money at the same time.
Exactly. And I think the reason they implemented it in that way was because they wanted to cut the legal aid bill more than any other motive.
So do you think the reason why you found this feeling of when one party isn't ready to start the mediation process and therefore the mediation process broke down was on the basis that mediation wasn't prepared for these clients with all of their issues that we're coming with, and they weren't properly trained, or maybe there wasn't, there was an influx of people wanting mediation and actually that wasn't working for them in the way that mediation was structured at that point, and therefore they weren't ready for those people, rather than necessarily the fact that, because in my head, this may be a naive of me, but is it the mediator's job to prepare and allow readiness for those coming to the sessions in order for them to then move on and have a good co-parenting alliance?
Almost facilitate readiness, perhaps. Make people
they should facilitate readiness. I think the real problem with mediation is where there's an imbalance of power, and that between the two parties, and that can be for any number of reasons. It can be abusive relationships, it can be financial in that one can access legal advice and the other hasn't got a clue where they stand. It can be, as I said, because one person was the driver behind the relationship breaking down and had disengaged and moved on already, and the other was still in a state of shock and not really able to, if you like, make those decisions at that moment. So For me, for mediation to work, you need to have a level as possible playing field between the two parties. And so I would say the job of the mediator is to spot when that's not the case. And as you say, to
or perhaps
facilitate
to have some
leveling up.
influence on that. Like, I'm just thinking that if someone came to you, and I guess, the rules as to how mediation can play out are also something that we can be much more flexible with than perhaps we are led to believe. So if we need to see someone a few times before we all get together, then we should. So I was just thinking that if someone came to me and I became aware of the fact that they were enjoying a level of power that probably wasn't creating a sense of equality for the other person, I might take it upon myself to talk to that person about the fact that they seem to have power. And I wondered about the effect on the other person, knowing that they had the power and knowing that they'd use it if they wanted to. And then perhaps meeting with the other person who might quite quickly sort of let me know that they're actually in a position of disempowerment and talk to them about that. So, in a way, I get this sense that mediation is kind of like works with the state of mind that people are in and just kind of accepts that as that's just how it is and there's nothing you can do about it. Was actually people, if they were helped, perhaps. Let's suppose that someone is being controlling and it's affecting their relationship with the other parent and therefore the relationship with their children. And they're given an opportunity to kind of reconsider the way they're behaving because they want to keep the relationship with the children. So they might, in their own minds, decide to take into account that they are being controlling and be less controlling. I kind of feel like, aren't we in a position where we should be more prepared to be more powerful? And I often feel this about mediation. Like some people, the case isn't serious enough for mediation. Some people, the case is too serious for mediation. It's like, shouldn't mediation be able to kind of deal with whoever it gets coming to?
Well, yeah, I would agree, ideally, but I think it comes back to Mitch's point about the level of training and the background of the mediator, because...
Or skill.
Exactly, and experience, all of those things. And certainly I think it would be good if we had a more nuanced accreditation system where people perhaps specialised in different aspects of mediation, and then you would have more confidence in the sort of service that could be there. But at the moment, it's potluck as to whether you get somebody who's
good or not,
who can spot power and imbalance, and as you say, take people aside. Whereas, I mean, I can remember one person I interviewed, and she said that in the end, the mediator terminated the mediation because she realised it was just another forum in which he could bully her. And, that is
awful.
The basis on which she told the person we interviewed the mediation should not proceed.
But that also means that the people in greatest need are least likely to get help.
Exactly. So I think it has to be done in the right way, with the right expertise at the helm, if you like. And I mean, we have... Don't get me wrong, and we interviewed a lot of people who were very positive about mediation, and they were so praising of what the mediators had done and how well they balanced the different things and how they brought them together and actually got them to agree against all of the odds. But there were also a lot of people who found the opposite, essentially. And I think we analysed what we thought that the causes that were, and one of that was practitioner expertise.
Yes. So how come people are getting to sit with clients with insufficient expertise, with skills that are not adequate to the challenges that the clients bring? How come I guess it's a similar situation. I often think in terms of family law, where almost universally everybody that I see has been through the legal process and is very unhappy with it. Spent a fortune, got nowhere, and are now more antagonistic towards each other than they were before. And also the children are absolute mess. How come a profession keeps on routinely kind of being unsatisfactory and yet remain in place? Like if you were a carpet cleaner and you kept cleaning the carpets really badly, after a while you wouldn't get any more work. So and it's like with mediation, how come we've got people mediating when they don't have sufficient skill?
I don't think it's a very well regulated profession in this country, actually. I think it could be done better. I probably won't be very popular for saying that, but at the moment, the Family Mediation Council has pulled it all together. It sets standards. I think that's all really good. But the level of training does vary between the different, and the type of training does vary.
I feel that the accreditation actually is assessing what needs to be there in good mediation. Like, if you're trying to get accredited, there's certain things you need to do, certain boxes you need to tick, and certain skills, I guess, you need to sort of demonstrate. But I just think about the subtle, nuanced skills that are required in human relationships, the sort of awareness that the therapist is kind of very thoroughly versed in, and the whole culture of supervision, the whole country of constant improvement and checking your own kind of ability or your own biases. So there's a culture of keeping an eye on yourself and keeping an eye on your work to make sure that you're constantly addressing what needs to be addressed. I just wonder about the nature of accreditation and to what degree does it pick up on such subtle skills?
The training, from what I understand, has improved and the standards have been changed. And I think certainly when we were looking at it, you didn't have to undertake this continuing professional development. It was up to you. So we found some people were still operating from the training they'd had 20 years ago or something of that nature. And I really don't think that's very professional, actually. I think that really should not be the case. We also found that people who had what we called they were hybrid practitioners, so they had some legal understanding and training, and they'd also had some counselling background. They tended to be the people who could bring it all together. But as you say, that the LASPO Act did mean that all of a sudden much higher conflict couples were being thrown into a system that was probably not that well prepared to deal with them at that time that we were conducting that research, which is why we brought after that research the creating. We did the project, the mapping paths to family justice project, and followed by the creating paths to family justice project, where we brought together all the mediation associations, all the policymakers, lawyers, everybody to try and make the system work better. But of course, the system, it's set up for competition as well. So that is problematic in that everybody's trying to do what's best for their clients rather than actually thinking this person's actually somebody who really does need a lawyer or somebody who really needs a child consultant expert here. It wasn't set up in a way that was conducive to a joined up approach where you were doing the right thing for people and helping them make the most appropriate choices in their circumstances, which is why I think triage would be a much better...
With perhaps like a case manager or something. I mean, I'm just aware of the fact, there was a report together in Australia where they looked at the family law system and all the different people in it, social workers and psychologists and lawyers and mediators and therapists, and found they were all kind of working against each other, or they certainly weren't working in sync with each other. So the poor clients were getting pulled from one place to another, and it would all depend on who they were seeing. So they were getting very contradictory kind of outcomes.
I mean, the best project that we evaluated, actually, it's a different project called Mediation in Mind, was something that was funded by the Department for Work and Pensions, where in a very poor area of the country in Stoke-on-Trent, and that funded people to have early legal advice, counselling for everybody, including the children, followed by child-inclusive mediation. Right. And that worked really well, even with the poorest, highest conflicted
Which goes
people.
To show, really, it's not about socioeconomics, really. Conflict is...
The counsellor was brilliant. The mediators were brilliant. The children loved the counsellors. And the fact that they had a say. The parents came to understand the other's point of view without everything reaching loggerheads. So, and the emotional readiness idea was worked so that they didn't bring them into a room together until the counsellors felt, it's okay.
Yeah.
They're not going to kill each other, sort of thing. But that obviously is an expensive project. And
It's
if the
big and
program,
clunky. I was just thinking about, and so often, I go to training things with lawyers, and they're saying, well, that'd be amazing, but I don't have those skills. And I'm thinking, well, you should, because you shouldn't really be working with these people and saying, I don't know.
you can refer. So, the
Do people
mediator,
refer?
not when they are set up with funding to do it as a joint venture, then yes, they do. When they are funded separately and they're all trying to get each other's clients, essentially, then I think that can, not always, because most people are professional, but you can also see there's temptation to think, oh, well, there's just a little bit of domestic violence. Well, push this to the mediation route anyway.
What I thought was really interesting when you brought up that it was working really well in Stoke-on-Trent is that you brought up child inclusive mediation and the voice of the child. And with your new book, Children's Voices, Family Dispute and Child Inclusive Mediation, I was wondering if that and the child's voice and the child inclusive mediation changes that dynamic. Does that impact, is that the thing that impacts the most?
Well, yes, in that was more recent research that we did. We interviewed children. So the Mapping Paths and the Creating projects Creating just interviewed a few children from the Family Justice Young People's Board.
Okay.
And they were very in favour of having a voice when parents separated. They felt that the child arrangements affected their lives and they should be able to express a view. They didn't want to make the decision, but to not be offered any chance to express what they thought was a travesty. And we realised that we hadn't actually asked the children. We'd only spoken to the parents and the mediators and the lawyers. So we had a separate project where we spoke to the children as well as some parents and some of the same mediators to see whether child inclusive mediation had progressed, because we had hoped to do more around child inclusive mediation in the original project, but there's very little going on.
You can't really research it, and no one's doing it.
We discovered that lots of mediators were qualified to do it, but nobody had the confidence.
I think that's about training. I know for a fact that training in some other countries is for child consultants much more comprehensive. It takes much longer. It's much more. I was quite taken aback when I looked at the nature of how child inclusive training happens in this country. It's very, very rudimentary. It's extremely lightweight. So I think if I'd had that degree of training, I wouldn't want to be suggesting it to my clients because I simply wouldn't know how to do it.
Exactly.
Right. So you're seeing a lot of people that like the idea of child inclusive mediation, think it's really good, knows kind of about the research, decides to do the course and the training, and then goes, I'm not really sure. I can't really do that. I don't really know how to do it, and don't ever implement it.
Yes, I think that's certainly what we found in the mapping project. When we went back for the second project we called the HEART project, the Healthy Relationship Transitions project, then many more mediators had undertaken more advanced training and were much more confident to do it. And they told us that once they had the confidence, because originally they were blaming the parents for being the gatekeepers and saying no. But when they had confidence, say, look, this is really good for the children. Yeah. The research shows it's good for the children. And they sold it, if you like, in the nicest possible way to the parents in a positive frame because they were confident about undertaking it. Then a lot of parents said yes. And the children, by and large, loved it. They all, even if they didn't, because so let's be clear, it's not putting the children in the room with the boring parents.
No.
That isn't what happens. They're seen separately and they're just allowed to express a view. They have control over what is fed back to the parents. They're not asked to decide which parent they want to live with, but they are asked their views about the arrangements and how they're feeling and how it's affecting them. And then they, with the mediator, agree what is fed back to the parents. And the children were really positive about that. And even the wider group of children, we had ran some youth panels with wider children whose parents hadn't necessarily separated. They all felt it was very important that children had the opportunity to be consulted, not be forced to do it, but be given the choice And those that had done it all felt it was what they described as cathartic. It was a weight off my chest. I felt I could say what I really felt rather than what I knew my mum wanted to hear or my dad wanted to hear, because they were bottling it all up and they were trying to, as children do, please both parents and actually be just not get in the way. But they also were a bit at sea about the process was, and the mediators were good at explaining that. They understood much better what the options were. And we were really, it was only a relatively small sample, but they were very, very positive.
So it sounds
about
like
it.
when the mediators are able to get the training that they need and the confidence that they want about, well, that they need around child inclusive mediation or just mediation in general, and maybe even more comprehensive mediation, that training should be changed on that. But that's a different conversation. But if that happened, then there's a possibility for more people to actually be ready and be possibly go through mediation because they've got the right mediators in front of them. And therefore, children's voices are also being heard, which in a succinct way will make mediation easier for everyone, because you're hearing the child's voice and you're able to not use that as a tool, but help that equal the flow of good mediation, and the child's voice is heard, and then better co-parenting alliance down the line doesn't necessarily need to go to court, but everybody's still being implemented into that process. So really, from what I'm hearing from you, is that mediation is the thing that needs to be funded and improved and training brought into, and whether or not that's lawyers being helped into those processes or whether or not that's psychologists being brought into those processes.
Mediators should be paid like barristers. And they should
I'm sure you think that.
and they should be, expected to have a very high level of skill.
Well, as they should.
So that clients become ready because of the process is so efficient and the skill of the practitioner is so high. Child inclusive happens as a matter of course because the mediator has a great deal of confidence in it. It really seems bizarre to me in a way that the clients are entirely dependent upon the luck of who they happen to sort of come across.
Absolutely.
And what I remember reading about you talking about kind of joined up, like collaborative almost state of the courts and the law and family solutions. What do you think about that? Explain that to me a little bit about kind of joined up family solutions.
Well, I think what we should be aiming for is appropriate dispute resolution for people. I also think the child's voice should be included, however a dispute is resolved.
Okay.
Children, in theory,
no matter what,
have the right to express a view under international law. And
they weren't asked about the separation, of course.
No.
They weren't consulted there. So that's just happened in spite of what they want.
Yes.
So then the process doesn't ask them either.
Although under the United Nations Convention on the Rights of the Child, they should have the right to express a view on all matters affecting their lives. What affects their lives more than their home being broken apart and arrangements being put in place without them having a voice? So I think mediation could be used for more people, but it's not suitable for everyone. And I think we have to acknowledge that. But it should be used in a way that brings the child's voice in. And I think if we do that in a sensitive and appropriate way, as child inclusive mediation done at its best does, then it could reduce the conflict quite significantly between the parents. Because if the child is telling one parent one thing and the other parent the exact opposite, it's not surprising that the parents are almost at war about it, because they each think the child supports their point of view, even though it shouldn't be like that.
Yeah.
And so what we suggest is that there should be a sort of family discussion, in a sense, not necessarily all in the same room at the same time, but it should be a three-way or however many children way conversation, so that you reach a resolution that everybody can be at least happy with and feel they fed into. That's not to say children always get their way. That's not what I'm saying. You're not asking them
to
choose.
And neither they want it.
No, of course not. But they want to be consulted. I mean, we had one little girl who said, I can't tell my dad I'm scared of him because he will think that it's my mum telling me to say this. And it's not, it's me. I am really scared of him. And her brother was very keen to see his dad. So they
It's
came to a
completely different.
compromise once the mediator knew how the little girl felt, that she would go to the door when the dad came to pick up the brother and say hello, but it was up to her whether she went or not, with the hope being that if she was really scared and there was reasons to be scared, that would all sort of
Also,
unravel at some point in
well,
a way.
the daughter would decide, well, I don't want to spend.
That if she did want to see her dad, and as she grew up, she felt there wasn't any reason to be scared of him, she would go and, they could go to the cinema or, but if she felt she was just being in an unsafe environment then, at that time, it wasn't good to force her. And the dad accepted that. But she did have to go and have a chat with him every day. Every day he came. So that was one thing. And then another case where actually the matter did end up going to court, where they were all convinced that the girls didn't really want to live with their father, even though this is what they had said, because they thought the father was going to abduct them and take them to a forced marriage. And actually the mother had a very chaotic life. She was British, he was an Asian man, and there was a sort of stereotypical assumption that that's what he was going to do. Whereas what they said very clearly in their own voices eventually was, well, we could do our homework at Dad's. Yeah. We want to go to university. This is how we want our lives to be, calm, controlled in that sort of environment. We want to see our mum, but we don't want to be dealing with all her problems all of the time, so we don't get our homework done.
So often the child's voice can also take away lots of the bias that comes with things, and the persuasion of one parent over another because of their economic background or their finances or whether or not they have legal aid or whatever. So when you have the child's voice implemented, it kind of softens that and takes away those issues as much. So in our child inclusive practice that we do, standard practice, we ask children what their 3 wishes for their family are. So I was just going to finish on asking you what your 3 wishes for separating families were, or for the family justice system was going forward.
Well, I would like to see appropriate dispute resolution implemented for everybody going through separation.
Okay.
And that would include children being given the opportunity to voice their views independently of their parents in an appropriate way, with appropriate weight being given according to their age and understanding, and for it to be a far less conflictual approach to resolving these matters. Where the power, if you like, is more neutralized and the voice of the child shines through in an appropriate way, and they're given feedback about what's good and what's not, about what's going to happen to them, and their views on how it should be taken forward. Because I think often they have great ideas, but it's impossible to achieve what they would really want to achieve.
Yeah.
But for them to understand that it can't happen right now, or there isn't enough money, or that maybe in a few years' time they can do what they're suggesting, or yes, there are things we can do now and we'll think about the other things. All of that will just...
Even being consulted is the big thing.
Exactly. I think it just... Because children's well-being is affected by parental separation. Yes, everyone says they'll adapt, and often they do. But I think they also bear mental scars.
Anyone who's had parents who have divorced would be able to say, "I was affected in some way because of through my life because of what happened."
I often find that word "children are resilient" very concerning, because yes, they may appear resilient, but maybe appearing resilient is their strategy for survival, and take into account. It was Donald Winnicott talked about how there was no such thing as a still and stable child in a chaotic environment. You cannot be surrounded by chaos and be all right, because this is your world, this is your sense of self. Everything you glean about yourself, you learn from the apparent interest and concern people have in you, and if they're in conflict, they're not showing much of that. So it's really important, I think, the enormous effect of parental conflict is understood at a kind of deep level. It's serious stuff. If a child was lying in the road having been run over by a car, everybody would be running around very quickly trying to do something about it. It's almost more profound than that because it's a lifelong consequence of growing up in a conflictual environment.
And I think building in more counselling into a system should be a priority as well. So if for those that need it and want it, I mean, some people manage this really well, but even the other thing that bothers me is where parents don't even get to mediation or a lawyer or a court, and they just make an arrangement.
Yeah.
And the child just has to deal with it. And some way of really giving them a voice, even in those situations, I think is important, just to have someone to talk to, perhaps at school. Perhaps we should just be aware that this is part of our world, but actually how giving children an outlet for their thoughts and feelings about the whole situation is really important when they're going through it, and indeed later on, as things develop, if they doesn't
It's an enormous
smoothly.
relief, I think, children to pass on their concerns to someone who seems to be interested in listening and obviously is going to be very careful with the information that's been given to them. I think it's such a load to lift off and hand it to the child consultant and know the child consultant's now got it. Child consultant obviously understands what I'm going through, appreciates what's happening. Enormous sense. Often people say after a child's been interviewed, "What did you do?" Just listen.
Well, there you go. Okay, well, that was amazing. Thank you so much.
Thank you very much.
Yeah, that was wonderful. So please like and subscribe and share this episode with your friends or colleagues. We'd love to hear from you. If there's anything in this conversation that sparked a thought, leave us a comment or send us an email at hello@billhewlett.uk. Thanks and see you next time.